This show is intended to help listeners understand the new opportunities that are now available to college and high school athletes as it relates to name, image, and likeness. The information contained in this show is only meant for educational purposes and is not meant to be legal advice or to establish an attorney-client relationship. Hello, everyone, and welcome to Court to Court with the Esquire Coach. I'm your host, Cassandra Ramsey, and I love to talk about all things sports, entertainment, and the law. I hope you all have enjoyed the special guest interview series and the entrepreneurial college athlete interview series that I have been doing lately. I think it is important that you all have an opportunity to hear from industry professionals who offer different perspectives working in college athletics and from college athletes who have actual real-world experience navigating this new NIL landscape, and as they share their experiences taking advantage of their NIL opportunities. So it has been a while since we've done an episode like this where we talk about some of the latest topics in college athletics that relate to NIL. And I think there's no better time to do it than right now, as we're about a little over a month into the college football season. And I thought that we should start with one of the biggest stories in college football this past week. And that is the University of Nevada, Las Vegas quarterback Matthew Sluka making his decision to leave the program and take advantage of his redshirt year. He made this decision as the program has been having a historic start to the season with a 3-0 start, and he decided that he would sit out the remainder of the season due to representations that were not upheld. In a statement that he made via social media, he stated, "I have decided to utilize my redshirt year, and I will not be playing in any additional games this season. I'm committed to I committed to UNLV based on certain representations that were made to me which were not upheld after I enrolled. Despite discussions, it became clear that these commitments would not be fulfilled in the future. I wish my teammates the best of luck this season and hope for the continued success of the program." According to ESPN, via Sluka's NIL agent Marcus Cromartie, Sluka was verbally promised a minimum of $100,000 by an assistant coach if he transferred to UNLV, and none of that money was ever paid. Once Sluka enrolled, there was no effort by UNLV's collective to formalize a contract at that amount. The school allegedly came back with a $3,000 contract per month for the next 4 months, which would amount to $88,000 less than the original amount. Sluka's agent maintains that Sluka never asked for more money once the team got off to a 3-0 start to the season. The only money that Sluka received was $3,000 to cover relocation expenses for his move, as Sluka was a graduate transfer from Holy Cross. Once the original amount did not come into fruition, he decided to redshirt so that he would be able to play a full spring at a new school and develop with his trainer this fall. So this story sent shockwaves through the college sports world as the college athletics landscape continues to shift, as college sports administration officials struggle to implement a new system that ensures equity and fairness for the players and all those involved. I bring up this story because I think there are two very important takeaways here for college athletes, for parents of college athletes, and for those who work to assist and protect college athletes. And the first one is to make sure that all agreements are in writing. This entire situation is predicated on a verbal agreement, and there isn't any paper trail that really dictates the understandings of both sides. The NIL collective for the University of Las Vegas, Nevada, says that they were not involved in any of this and that no agreement with the NIL collective was ever made to Sluka. But it's important to have all of your agreements in writing so that it's clear who promised what from both sides, who is supposed to receive what, and when all of those things are supposed to happen, when all of those promises are supposed to be met. Because essentially in this situation, they have found themselves in a he said, she said situation where, it's really unclear how this will turn out, whether or not if they will continue to press the issue or if there will be any types of lawsuits or litigation. But the important takeaway is to make sure that all of your agreements are in writing. It's clear what you're supposed to be getting and from whom, whether it's the NIL collective or a third party that you're getting a NIL deal with. You want to make sure that the agreement clearly states the terms, the parties involved, what the deliverables are, when those deliverables are supposed to be given on both sides, and when the agreement would end, as well as other things that need to be included. But those are just some of the highlights for you to look for as you're considering various type of contracts as a college athlete. The second takeaway is for you to know and understand the NIL law of the state of the school that you're going to be attending, and for you to know and understand the NIL policy of the school that you are attending. Like I just mentioned earlier, UNLV's NIL collective, Friends of UNLV, stated that no formal NIL offers were made to Sluka during his recruitment process, and that Sluka only discussed terms with the offensive coordinator. And so this would be a problem because Nevada's NIL law prohibits any payments being made to athletes directly from the schools. So if Sluka and his parents already understood Nevada's NIL law, they would have been able to question, like, hey, are you the correct person for me to be talking to about this deal, as I understand that schools and school officials are not able to offer direct payments to the athletes. So, I just think that this is just a very teachable moment for current and prospective college athletes who may be considering transferring. And, you just need to learn from this situation and make sure that you have the proper knowledge and resources to make sure everything is on the up and up. Now, let's turn to what I believe is the prevailing, developing big story within college sports right now, and that is the House versus NCAA case settlement. If you have been hanging with me for a while now, or even if you're just a casual sports fan, I am sure that you know that there is tremendous change taking place in college sports. And that change is due to 3 letters, NIL, name, image, and likeness. On this show, I have previously discussed what NIL is and how college athletes gain the right to profit from their NIL, but I will briefly summarize here. College athletes gain the right to profit from their NIL on July 1st, 2021, after a series of state laws went into effect, giving college athletes the ability to profit from their NIL, and this led the NCAA to adopt the interim NIL policy, allowing athletes at their member schools to profit from their NIL. While state legislation got the ball over the line, it definitely had some assist with several court cases. The first one being Ed O'Bannon versus the NCAA. Back in 2009, former UCLA basketball standout sued the NCAA, EA Sports, and Collegiate Licensing Company for the unauthorized use of his NIL in a video game. And ultimately, he won the case, as the judge found that college athletes should be compensated for the use of their NIL in video games. But that case was significant because it was one of the first times that it was shown that the NCAA's rules are subject to antitrust law. And that game also laid the groundwork for one of the biggest returns in college sports that we saw this summer with the return of the EA Sports college football video game. And that case also laid the groundwork for other cases, such as NCAA versus Alston, which was the big case that you may also hear about that went to the United States Supreme Court a couple of years ago. And even though that case had nothing to do with NIL, it was where the Supreme Court made it clear that the NCAA's rules are subject to federal antitrust law. While that case was going on, there was another case that was brought against the NCAA known as House versus NCAA. So that case was filed against the NCAA on June 15th, 2020, when a Arizona State University swimmer Grant House and then University of Oregon women's basketball player Sedona Prince sued the NCAA, alleging that the Power Five conferences and the NCAA were illegally imposing restrictions on the compensation that D1 athletes could receive for the use of their NIL. Although college athletes gained the right to profit from their NIL during the time that this case was filed, the case still moved forward because they were seeking damages for lost NIL broadcasting revenue, lost NIL video game revenue, and lost revenue for third-party NIL deals. Soon after the Alston case was decided by the Supreme Court, we had another case come up, which is Hubbard versus the NCAA. In there, former Oklahoma State University football player Chuba Hubbard and former University of Oregon and Auburn University track and field athlete Kiera McCarroll filed a class action lawsuit against the NCAA and Power 5 conferences seeking to recover damages for not being allowed to receive what has become known as Alston Awards. So as I mentioned, the Alston case didn't have anything to do with NIL. It actually questioned whether or not if the NCAA should be allowed to restrict the amount of education-related benefits that athletes could receive. And the court found that they should not, that they should no longer be able to restrict education-related benefits while still being allowed to restrict non-education-related benefits, or what the NCAA would consider to be pay-for-play. And then the third case, Carter versus NCAA, is where a Duke football player, Dwayne Carter, and Stanford soccer player, Nia Harrison, and TCU basketball player, Sedona Prince, sued the NCAA seeking an injunction that would prevent the NCAA from enforcing its pay-for-play rules and for past damages that athletes would have received if those rules were not in place. So I mentioned all three of these cases because these cases have all been consolidated under one, now known as House versus NCAA, for the purposes of the NCAA Power 5 conferences and the attorneys representing the college athletes seeking to reach a settlement agreement. So why is the NCAA trying to settle? They're trying to settle because if they don't, they face up to $4.3 billion in damages if all three of these cases go to litigation. So they believe that it was in their best interest to try to work towards a settlement. So in May of this year, it was announced that the NCAA and Power 5 conferences reached a historic settlement in this historic case. And soon after this, I began to get questions from a lot of different people about, what does this settlement mean? How could we prepare for the settlement? And the first thing that I would say is by acknowledging that nothing is set in stone yet, because the settlement still has to be approved by the federal district court judge presiding over the case. So in a lot of ways, it seemed like people were really jumping the gun and discussing the settlement as if it were a done deal. But the settlement is not a done deal. As a settlement hearing was held last month, where the federal district court judge presiding over the case did not grant preliminary approval of the settlement and essentially told the attorneys to go back to the drawing board due to several concerns that she had with the settlement language. Before I get into the concerns that the judge had with the settlement, I want to first start by going over some of the high points of the settlement agreement. So the first major deal highlight from the settlement is that the NCAA and the Power 5 conferences would be required to pay $2.8 billion in damages, which is significantly lower than the $4.3 billion that the NCAA faces if those three cases go to trial. So they would be required to pay those $2.8 billion in damages over a 10-year period to approximately 14,500 Division I athletes who played from June 15, 2016 until November 3rd, 2023. Even though the Power 5 conferences were the only conferences to be named as defendants in the lawsuit, other D1 conferences are expected to contribute to those damages. In fact, they are expected to contribute around $990 million of the $2.8 billion. And not all conferences were happy about that. Some voiced concerns about being required to pay for damages in a case that they weren't even named in the lawsuit, and for damages that essentially their athletes are not going to get any benefit from. So specifically, Big East Commissioner Val Ackerman expressed opposition to the settlement prior to the NCAA and the Power Five voting for approval, and other schools and officials have, voiced some concerns over that part of the settlement, but that is what was voted for. So at least for now, it seems that if the settlement is approved, that is what will be required of all the D1 conferences. The second highlight involves current and future college athletes, because the first highlight addresses the benefit that past college athletes will receive for not being allowed to take advantage of NIL opportunities as a college athlete. So the second point mainly involves current and future college athletes, and this is where the settlement would allow colleges to engage in revenue sharing with their athletes up to approximately $22 million annually. This means that colleges will now be able to pay their athletes for things like ticket sales and NIL and media rights deals. And that is a major, change from the current system of amateurism, where, colleges are not allowed to pay their athletes, not allowed to engage in pay for play. But here, under the settlement, they're somewhat making the distinction, still not calling it pay for play, but revenue sharing with the college athletes. And the third highlight that I would like to point out is scholarship caps will be eliminated and new roster limits will be implemented. This means that schools will be permitted to give a scholarship to every member of their roster as long as they stay within the newly set roster limit. So these are just a few of the highlights of the settlement. The settlement also encompasses several other changes, as well as it's a pretty lengthy settlement proposal. So now, why did Judge Wilkin, the federal district court judge presiding over the case, not grant preliminary approval of the settlement? So during the hearing that was held on September 5th, Judge Wilkin voiced several concerns regarding the settlement. Overall, she was concerned that the proposed model would take away freedoms and potential NIL opportunities that college athletes have been enjoying since July 1st, 2021, when college athletes were granted NIL rights. The judge questioned the distinction that the NCAA was attempting to create regarding pay for play from third parties, such as boosters, when players will essentially be allowed to engage in pay for play with their colleges via the new revenue sharing model that the settlement intends to create. Judge Wilkin also voiced concern over the system that the settlement proposed to create that would distinguish whether a NIL deal was, quote, real NIL or a NIL deal that is really pay for play. And to accomplish this, college athletes would be required to disclose NIL deals that are valued at $600 or more, with the goal of identifying deals that vastly exceed the perceived fair market value for NIL deals. Another major issue that Judge Wilkin had with the settlement was the NCAA's attempt to try and regulate and in some cases prohibit payment to athletes from NIL collectives. We've spoken of NIL collectives previously on this show and their role in the current college athletics landscape. According to Open Doors, NIL Collective plays a vital role in the recruitment and retention of college athletes. NIL collectives make up 80% of the total NIL market, and 81.6% of NIL compensation comes from NIL collectives. Judge Wilkin voiced concern over college athletes having these opportunities from NIL collectives and those opportunities being taken away or significantly diminished under the settlement proposal. At the core of Judge Wilkin's concern is the possibility that the proposed settlement would create a more restrictive NIL market than the one that college athletes have been currently enjoying. It is for this reason that Judge Wilkins sent both the attorneys for the college athletes and the attorneys for the NCAA back to the drawing board. And on September 26, both sides filed new documents responding to Judge Wilkins' concerns. Per The Athletic, the brief stated that the parties have made changes to clarify the provisions so that it is explicit that the agreement is only allowing the continuation of existing NCAA rules, which already prohibit so-called faux NIL payments in narrow and more objectively defined circumstances. So it remains to be seen whether this newly filed or changes that have been made to the settlement proposal will satisfy Judge Wilkins' concern. During the hearing, the NCAA's attorney was pretty clear that the NCAA is set on the agreement as is and would likely not be willing to make major changes. So if the settlement is not agreed to, there's still a strong possibility that these cases could go to trial. And just over the past day or so, it was reported that Michael Hossfield, who was the attorney who represented Ann O'Bannon in O'Bannon versus the NCAA, filed an opposition to the amended version of the proposed settlement that was entered on September 26. So here's yet another wrinkle and an attorney who has been instrumental in this college athletes' rights movement through his work on the O'Bannon case that has voiced concern with the settlement. So whether or not that will have any bearing on whether or not the settlement is approved, we will all just have to wait and see. In other college sports news, the University of Tennessee recently made headlines when the university announced that fans of all sports would be charged a 10% talent fee on tickets to help pay athletes as part of the new revenue sharing plan that is set to begin in 2025 if the House settlement is approved. And what is believed to be a first-of-its-kind arrangement, the Tennessee athletic director, Danny White, recorded a video explaining to fans that the fee was being added as part of the university's plans to continue to dominate college sports. In addition to the 10% fee that will be added generally to all sports tickets, there will be an additional 4.5% increase on football tickets. Danny White stated that we want to be a leader in college sports. That means we want to be a leader in revenue sharing. Per ESPN, the University of Tennessee football program turned a $75 million profit in 2023 after $134.9 million in revenue and $59.1 million in expenses. Instead of simply raising ticket prices, school officials stated that they wanted to be clear and transparent as to the reason for the increase and where the money is going. So what do you guys think? Do you think that we will see other schools implementing similar talent fees? Do you feel like this may be a school's way of pushing off those added expenses onto the general consumers and sports fans? Just let me know what you guys think, and if you would want to see this type of thing continue, or if it would impact your decision to attend the game. Well, this concludes today's episode of Court to Court with the Esquire Coach. I want to thank you for joining us. If you like the content that you saw here today, please subscribe to my channel. And if you would like to stay up on the latest with the Esquire Coach, please follow the link in the description section and sign up for my NIL contract checklist and join my newsletter. Again, thank you, and we'll see you next time.